In the United States, the Alabama State Senate passed the Vulnerable Child Compassion and Protection Act, prohibits gender change therapy for minors, prohibits withholding of certain related information from parents. A law designed to make the surgical or chemical mutilation of children a felony. This bill and another that has passed the Alabama State Legislature will, when combined, make the surgical or chemical mutilation of children punishable by up to 10 years in prison or a $15,000 fine. This is a refreshing development in the ongoing war against the mutilation and sexualisation of children by the left and their queer normative activist allies. We will examine the Alabama law and look at how it can be strengthened and introduced here in Australia at a federal level. My fellow Australians, welcome to another episode of Advancing Australia. My name is John Andrews. This video is a bit of a white pill and it follows up on my video on transgender and queer affirming laws in Australia, which was a review of federal court rulings with respect to trans children and of state laws criminalising heterosexuality in respect to families and children in crisis. We will also look at an innovative law in Mississippi that separates biological sex from gender expression to protect female sports. So the bill in Alabama was championed by the Eagle Forum of Alabama, a conservative political action group. On their website, they host many of the videos of the public hearings and the testimonies that were heard by the legislature during the investigation of the need for this piece of legislation, including the testimony of an endocrinologist that simply destroys the so-called medical arguments for the current therapies that are being used to treat a mental disorder. It's very short and I've linked it at the top of the list of sources below, and you should check that out if you're interested. It's only about a 3-minute video, it's pretty full on. In September 2020, when the legislation was introduced, Eagle Forum Executive Director Becky Gerritsen said, quote, "The legislation is necessary for many reasons. One is that the long-term effects of puberty blockers and cross-sex hormones have not been studied. Another vital statistic is that after the sex reassignment surgery, transgender identified people are nearly 20 times more likely to die by suicide than the general public." End quote. The two bills make it a felony for medical professionals to treat so-called transgender minors under the age of 19 with either stage 1 or stage 2 treatments. And you'll remember stage 1 being puberty blockers and stage 2 treatment being cross-sex hormones. Violators would face up to 10 years in prison or a $15,000 fine. And briefly, this law does mention 19-year-olds, and that is the age of majority in Alabama. The law makes these offences Class C felonies, and under Alabama Code, quote, "sentences for felonies shall be for a definite term of imprisonment, which imprisonment includes hard labour. Within the following limitations for Class C felony, not more than 10 years or less than 1 year and 1 day. So this is effectively a mandatory prison sentence. In addition to banning stage 1 and stage 2 treatments, the law also makes it illegal to, quote, "withhold from a minor's parent or legal guardian information related to a minor's perception that his or her gender or sex is inconsistent with his or her sex." This is a very simple bill. It's only 1,400 words and importantly contains these words, quote, "Studies have shown that a substantial majority of prepubescent children who claim a gender identity different from their biological sex will ultimately identify with their biological sex by young adulthood or sooner when supported through their natural puberty. There is no psychological or medical test that can differentiate between the majority of children who will desist from their gender incongruence or the minority who will not. Research shows that the administration of puberty blocking medications or cross-sex hormones forecloses the possibility of a natural recovery from this condition," end quote. Importantly, the law, quote, "does not apply to a procedure undertaken to treat a minor with a medically verifiable disorder of sex development," end quote. This covers a range of medical and genetic abnormalities that are well documented and are often the sort of examples that radical activists give when talking about these issues as reasons for allowing the chemical and physical mutilation of children, of otherwise healthy children. The Alabama law is a great template, but it could have gone further, as a Victorian law affirming queer normativity does. I discussed this law in my previous video on these issues. The law could criminalise the movement of children or exposing children to teleconferencing or e-consultations across state lines, or the movement or shipping of drugs across state lines in order to receive these radical and damaging treatments. How could we pass such a law in Australia? 2021 Young Australian of the Year Grace Tame gave an address to the National Press Club on 3rd of March, which was reported in The Guardian under the headline, "Share your truth, it is your power." Grace was raped while she was in year 10 by a 58-year-old male teacher that was later found with 28 multimedia files of child pornography on his computer. He received 2 years and 10 months jail for this crime, which to me is woefully inadequate. I'm in the castrated or killed camp when it comes to child sex abuse, and to me the chemical or physical mutilation of children is morally equivalent. The reason I raise this speech and Grace's story is because in her speech she said this, quote, "In Australia we have 8 state and territory jurisdictions and 8 different definitions of consent. We need a uniform state and federal national standard and definition of consent. Only then can we effectively teach this fundamentally important principle consistently around Australia," end quote. So let's have a conversation around consent. In my previous video on trans law, I mentioned the concept of consent and Gillick competence, that in Australian law, inherited from Britain, that whether a child is competent will generally depend on whether they are able to demonstrate that they understand the content of the treatment, its side effects, its negative risks, and the physical changes it will cause. Further, the Tavistock inquiry in Britain found that children were unable to give consent as they were unable to achieve Gillick competence. Paragraph 139 of the Tavistock judgment said, it will obviously be difficult for a child under 16 to understand and weigh up such information. Although a child may understand the concept of the loss of fertility, for example, this is not the same as understanding how it will affect their adult life," end quote. A British court has found that children cannot be competent to understand and weigh up profound changes made by these chemical and surgical interventions. And right now, the Young Australian of the Year has opened up a national debate about consent and sexual consent. So therefore, there is an opportunity to combine these issues in very simple federal legislation. Finally, we have a brief look at a law in Mississippi that bans transgender athletes competing in women's sports. Again, we visit my good friends at Pink News with the headlines, quote, "Mississippi passes dangerous bill banning trans athletes from school sports, defying evidence to discriminate," end quote. And it goes on to say, quote, "The discriminatory bill marks the first piece of specifically anti-trans legislation to be added to the books in 2021. Unfortunately, it's unlikely to be the last," end quote. And it goes on to mention that SB 2536 in Mississippi is just one of a raft of anti-trans bills launched in at least 20 states. Okay, so I had a look at that bill, and it's called the Mississippi Fairness Act. And it aims to, quote, "designate its athletic teams or sports according to biological sex, to provide protection for any school or institution of higher education that maintains separate athletic teams or sports for students of the female sex," end quote. And this seems perfectly sensible to me. And it actually aligns with trans ideology. The ideology holds that biological sex and gender expression are not linked. And this law has decoupled biological sex and gender expression such that competitive sports have been reclassified and divided between biological sexes and not genders. The Mississippi law delivers on the promise of separating gender expression and biological sex, so I don't see why trans activists are so upset. It's based on their own gender theory. No one is stopping transgender athletes from building their own sports divisions.